Okay, so I'm here to talk to you today about some preventative measures from the employment side of things, and the old saying that we had up before, the best defense is a strong offense, and not to pile on the Browns, but they clearly don't get that. But hopefully, as a result of going through this in light speed and getting you in and out of here, we will prove to you that that is the case. So the first slide, I'm just going to skim over because these are all the things that I think you should put in place or your client should put in place in 2014 to put you in a better position to avoid unnecessary employment litigation and claims with our friends at the EEOC, the OCRC, the DOL, and various other fun government agencies that we get to deal with in the employment group. So real quick, we're going to go through each of these in more depth, but employment applications, handbooks, employment agreements, non-compete, non-solicitation agreements, severance agreements, supervisory training, ADR programs, and employment law audits. So employment applications. It's remarkable how many people cheap out on employment applications and they just go to Office Max and they pull something off the shelf, or they find something on the web, or they steal somebody else's stuff, and they've had the same employment application for since disco was hot. And I get these employment applications and they ask all kinds of I don't have to beat around the bush, illegal questions like what year did you graduate from high school, or what church do you belong to, or who knows what else. Well, those applications went out, again, when white suits were cool, and if you still use, or if your clients still use employment applications from that era, they're illegal on their face, and they're going to instantly get you into trouble. Have the applications updated. It's a fairly simple process, and there's lots of good stuff that you can learn early on with a good employment application that you're not going to have in your disco era ones. So I list a bunch of them. You find out about the educational background. All of this stuff is very helpful to, as my friend who's also a client has one of the better background screening companies, he's got a statistic that would tell you that over 90% of people lie on their resumes. So are you going to believe that someone graduated from Harvard magna cum laude, or are you going to ask it in the application and have a reference check procedure to see if that's actually the case? Prior employment, when you see a job and then you see a gap of 3 years and then you see another job, well, what happened in those 3 years? That's important information to know as well. References. If they are giving out references, you have the right to check them. Most people are not trained HR professionals, and you can glean a lot of really good information by following through on reference checks. You'll find out about those in the application. Skills and experience. How many people have seen on people's resumes they're completely proficient in Word and Excel and Office and all these things, and you get them in the seat and they know nothing about even how to turn on a computer? If they said that in the application and you sit them in the chair and they don't know how to do their job, you've got an instant ability and another document in your arsenal to say, hey, you lied to me from the get-go, I've got the right to terminate you for it. Restrictive covenants. Even as early as the employment application, you can put certain restrictive covenants in your documents that can be binding. I don't want to rely on an employment application because you haven't really given anything yet. However, it should be part one of what's coming next, which are actual restrictive covenants, and then you've got kind of a belt and suspenders approach to making sure that there's no question that employees knew when they came through your door they were going to be subject to some restrictive covenants. Criminal background screening. This is a real hot area right now with the EEOC, where everyone is familiar with the application question that says, have you been convicted of a felony in the last 7 years? Nod, everybody, if you've seen that before, yeah? So the EEOC hates that box. They hate that question. And they are going after not just mom and pop companies, they're going after huge companies, suing them because they believe that when you ask that question, it's inherently discriminatory. Because a higher percentage of minority applicants, the statistics, they would argue, would show you, have a greater incidence of criminal backgrounds, you are screening them out of the process early on, and therefore that practice is discriminatory. Now, if you want to read some really funny judge-made case law, there's a judge in Maryland who took the EEOC to task and basically said that their math was fuzzy, would be doing a disservice to what the judge ripped into the EEOC about. Basically said that their EEOC math was worthless. and that their whole premise for this ban the box is worthless. You would think that a strongly worded federal court judge decision would stop the EEOC in its tracks. What did they do in reaction to that terrible decision where tons of attorney's fees were paid because the case was deemed frivolous? They sued 4 more companies. They don't care. They have the federal mint behind them, and they're going to absolutely continue to sue, and it's working. At least 11 states, maybe 12 at this point, have passed ban the box legislation, requiring employers not to have that question on their application anymore. Ohio has not gone yet. Yep.
Are you allowed to make a hiring decision based on not hiring somebody based on a previous conviction?
Say that again?
Are you allowed to make a decision to not hire somebody based on a previous conviction?
Okay. So what does the EEOC want you to do? What the EEOC wants you to do, and I represent a couple of large staffing companies, it's a nightmare for them, because let's say Lubrizol wants my staffing company to hire 200 employees for them. So the staffing company knows Lubrizol will not hire felons. They know it. It's an absolute non-starter for them. They've got trade secrets, they've got all kinds of proprietary information, they've got precious metals, they've got chemicals, they've got expensive stuff. They know Lubrizol won't accept any candidate from them who has a criminal record. So, do you want to take on that lawsuit with the EEOC? My staffing companies don't, so they take that box off of the application question, and they have to interview for 200 people that they're trying to employ instead of interviewing 300 people. They may have to interview 1,000 people now and take on all the waste and the costs and the expense. And then once you interview the individual, you can ask the question, but you have to have a job-based reason for asking the question even at that point, according to the EEOC. And keep in mind, this is not a law. This is a rule that the EEOC just decided. And you almost have to tip your hat to President Obama. He's finally figured it out. He can't legislate anything. So he has enforced the EEOC, the DOL, OSHA, all the government agencies who can enforce their own rules to do just that. They're making rules and they're enforcing them. So in answer to your question, you can ask the question and you can deny employment once you talk to them. But the businesses have to take on all the expense and costs that go with it. But good question. I mentioned an aggressive tactic that some employers are starting to take, and that is on the application, you can actually have a clause in there that says instead of a normal statute of limitations, which under Ohio law, 2 years, 6 years, depends who you talk to, for employment discrimination cases, you can shrink that statute of limitations down to 6 months or something much shorter, just by the fact that they applied for a job with your company and they understood it when they signed up. Also increases the chances that you're not going to get sued. Okay. Handbooks. I do a lot of this work. There are a lot of other people, let's be kind and call them charlatans out there doing this work out there. Payroll companies who will tell you, well, for free, for no cost, we'll do a handbook for you. And one of my homegrown, I'm from Rochester, New York. There's a large payroll company out there that shall go nameless from my home city that starts with a P, that will put out an employee handbook that is not ready for Ohio law. It has very little, if no, Ohio law provisions in it, and in some cases contradicts Ohio law, but they continue to pump out this handbook, and I see them all the time, and I have to revise them because they don't apply here. Do not steal another company's handbook. They're not your handbook. Do not take a handbook that was created in California or Oregon or Montana, any of our nuttier states that have bizarre employment laws that they're very nice places to visit, but you don't want their employment laws in your handbook. Customize your handbook. It's a very low cost, very easy process. We can do it for anywhere between $1,500 and $2,500, depends on the work and the number of locations. And it's good for the employer, always, assuming your supervisors follow them. I'll get to that in a second. So handbooks are your greatest friend. They will absolutely pay for themselves multiple times over because the EEOC, the OCRC, workers' comp, unemployment, if you've got that document in place and you've got the authorization form showing the employee knew all about it and hopefully they were trained by someone like myself or a trained HR person on the handbook policies, you got them. And that protection is worth its weight in gold. And I list out a whole bunch of the various provisions that I put in just about any handbook. Just a couple of them off the top. At-will disclaimers. Handbooks should have at-will disclaimers throughout. There's very good case law in Ohio that says if your handbook says that, you can basically ignore the offhanded supervisor comment that says, hey, Joe, you're a great employee. You keep doing what you're doing. You've got a job here for life. If you've got a good handbook with at-will disclaimers that say these little promises mean nothing, that's a good defense to those kind of claims. Harassment policies, of course, you need to have EEO policies and harassment policies in place. More importantly, you need to train your supervisors on that, and we'll get to that more in a second. FMLA. Big FMLA, what does that stand for, everyone? It's the Feed My Lawyer Act. It's the greatest piece of legislation for defense lawyers probably ever. It's an atrocious law to administer. However, you need to have 50 employees or more to actually qualify for it. If you stole someone's handbook or you took a handbook off the internet, it may have an FMLA provision in it. If it does, the law is pretty clear. You put it in your handbook, you've bought the FMLA. You do not want the FMLA unless you are eligible to be covered by the FMLA. Okay? FLSA exemptions, wage and hour DOL, they're going crazy these days. You need to have provisions in your handbook that require employees to come to you first to fix their wage and hour issues. It's a great way to, number one, fix these things before they go to an outside agency to alert the government to it, but it's also just smart HR to fix problems early on that are probably very little in scope before they become wildfires that are out of control, dealing with hundreds of employees that have the same problem within your organization. ADA policy. I didn't used to put this in handbooks, but now we do. Why? The ADAAA, lots of A's, but they amended the ADA in 2009, and who here has a sore back? You're disabled. All right. Just about anything constitutes a disability these days. So your supervisors need to be trained exactly on how to deal with the employee coming to them and saying, I've got this malady or that malady, and how to react. The government now, they do not want you to even ask the question if the person is disabled under the law. Believe me, they are. You have to deal with the step 2 part of the equation, and that is, can you accommodate that disability? Whether it's a sore back, a toughed out hammy, a sprained ankle, I don't care, you're disabled. Can you accommodate it? Okay? Breastfeeding policy, social media policy. Again, you have to be eligible for the breastfeeding policy. That got slid in with a piece of healthcare legislation a while back, and I didn't think this needed to be a law. I thought people would actually have the common sense to do this kind of stuff until I had the fortune of having an HR friend in Columbus who worked for a rather towel snappish college fraternity style law firm that thought it was very funny to create their own, what they called the boob room, and it was essentially a broom closet that they converted into a place for women to pump milk, and it was maybe 3 feet by 3 feet, and they posted all kinds of pictures of women's breasts all over the wall and called it the boob room in big bold letters. And my friend, the HR person, came to the managing partner and said, you can't be serious. We can't do this. And he said, well, if you don't like it, there's the door. Why don't you quit, sweetie? And she did. And we threatened to sue them. And before she left, I had her take pictures of that great room. And that case, Jones Day on the other side, settled in less than a month for big dollars, and that HR person didn't have to work for a few years. The breastfeeding policy, very easy, very simple, makes sense. Have a room, have it private, have it be able to be locked, and don't do what another company did, have video cameras in the room. That was a bad lawsuit too. Social media policy. I'm getting a lot of these days. They're very necessary, I would tell you, in this day and age when employees forget about using your computers during the workday. Even if you have protections on your computers, they can just pick up their phone and do the same thing that they could do on your computers by phone. You need to have policies in place that tell people right from wrong. Employment agreements. You're not going to hear me say that your maintenance crew needs to have employment agreements, but if you have employees that can hurt you, or if you have clients with employees that can hurt you in some way, if they leave you, then having an employment agreement in place is far better than not. Handbooks are wonderful things, but one thing they are not contracts. So if you want to enforce something like a non-compete, you can put that in your handbook, but it's not worth the paper it's printed on. It's nice to have in the handbook, it's a reminder, but it's not a contract. You need a standalone agreement for that. And so if you've got employees that could, if they left you, solicit your clients, solicit businesses, steal clients from you, steal confidential information, proprietary information, those are the types of employees I'd like to see with employment agreements. Can you have an employment agreement with an employee who is an at-will employee? Absolutely. Absolutely. We draft them all the time. And the law is very clear now. You do not have to hand them $100 like you used to, or $1 or $10, and say, here's some money, sign this contract. Now there's consideration for the agreement. Their next day of employment is sufficient consideration to give them an agreement. So you can do it midstream, and I would encourage you and your clients to do it. So I list off a bunch of the elements of an employment agreement here. Only one I'm really going to talk a little bit more on is the non-compete, non-solicitation provisions. We'll get to those in a little bit. Confidentiality, trade secret, at-will versus just cause. So at-will versus just cause. We are an at-will state. We are not a right-to-work state, but we are an at-will state. At-will, you can terminate an employee for any reason under the sun, as long as it is not an illegal reason or for retaliatory reasons. That said, employees can leave you at the worst possible time. We've got a bunch of accountants in the room, yes? Yes. Imagine if 20 of your best accountants decide to leave on April 12th. That would be pretty bad, wouldn't it? Want to know what you can do about it? Nothing. And that's the balancing act that keeps at will the law of not only the state of Ohio, but 49 of the 50 states. Want to guess the wacky state that doesn't follow at will employment? Good guess, but wrong. I mentioned it before. It's Montana. Montana. But even they follow a version of at will employment. So those are the things you need to think about when you're doing employment agreements. I list out a bunch of others. Severance and general release provisions, of course, can also play in there too, and I'll get to those. All right, non-compete, non-solicitation agreements. Are they enforceable? Absolutely. In the state of Ohio, there's very good case law that will tell you that they are enforceable. That said, if your non-compete says that you cannot practice accountant work, accountancy in the entire planet, you might have some trouble enforcing that. It's far easier to enforce a non-solicitation agreement than it is a non-compete, and it makes all the sense in the world. Do you want to tell an accountant, for instance, that they cannot practice what they've spent their entire life mastering? Judges don't want to pull that trigger. That's a tough one. However, will judges protect the clients that that accountant came into contact with while they were at the firm? Absolutely. That makes all the sense in the world. And accountants, I will say, got this right earlier on than most people did, and that is they know that people hire the accountant and not necessarily the firm. So lots of accountant non-solicitation agreements that I write or that I review have in there automatic, what I would call liquidated damages provisions. So they say, look, we know that you're going to go out there and be an accountant somewhere else. We even will acknowledge there's a chance that the client is going to follow you and not stay with us. If that happens, you owe us X. And it's usually some percentage or 100% of their last year's billings or 2 years or 3 years. Okay? Makes all the sense in the world, and it's much easier to enforce because, again, it makes sense to a judge. So those kind of provisions are common. Yeah?
What if the client follows you without any solicitation whatsoever?
Yeah. I doubt it. I immediately dispute the premise because you didn't say at all that you left. They just guessed where you landed. You probably had a conversation with them. But let's leave that to the side for a second. The answer is it doesn't matter because most non-solicitation agreements, at least non-solicitations that I or my partners would draft, would say direct or indirect solicitation. You can't accept work from that client. That's a really good little tweak to most solicitation agreements.
Can you accept new work?
No, no work. No work. You don't want them taking any work from a current client of your firm. So there's very specific good language you can put into these agreements to prevent just that from happening. Blue pencil rule or the black robe rule. You can have the greatest non-compete, non-solicitation in the world, and it's whatever the person in the black robe says it is. They can take out their magic blue pencil and just eviscerate it. They can change it, they can alter it, they can edit it, and the good judges will use that as a club to get a settlement in most cases. They'll say, go outside and get this thing resolved, or I'm going to pull out my magic blue pencil and you're not going to like what I do to it. Very effective. Must be reasonable in scope. Again, I used the globe example before. You want to limit the scope of these non-competes and non-solicitation agreements as much as possible. If you're an Ohio company and all of your clients are in Ohio, having a clause that says that you're prevented from doing X, Y, and Z in every state in the country is not that great a protectable interest to enforce. Someone's going to question you on it, and you're not going to have a good answer. And I mentioned the solicitation of clients and employees and liquidated damages.
Excuse me.
Yep.
Are the non-compete agreements typically like an all or nothing thing? For instance, I see a clause in there that says if something is ruled invalid in the agreement, everything else in the balance is still enforceable. So will a judge like to draw toss out the whole agreement? Or for instance, if you say you can't compete with the United States, they rule that too broad and they still enforce Ohio.
Yeah. Again, it's blue penciling. It's whatever they say it is, but chances are a judge is going to say, well, I'm not going to enforce it outside the state of Ohio. That's stupid. But I am going to enforce it in the state of Ohio, or I'm going to only require the client to not compete with customers that he met or learned about when they were at the firm, or it's going to be some different variation of it, but they're not going to throw the entire agreement out, and probably what's going to happen is you're going to get a somewhat more limited enforcement of the agreement that you have. Yep. Severance agreements. I view severance agreements as a wonderful litmus test for shifty ex-employees. I said shifty with an F in there. Be very careful of pronunciation when you're in the microphone. So shifty employees, you've got an employee that you're not quite sure whether they're going to sue you or not. I love to hand them a severance agreement because in my world, I don't trust anyone who doesn't accept free money. And that's what a severance agreement really is. It's free money. There's no law that says that you have to pay anybody severance, but if you're going to do that and you're going to ask for in return a release and waiver of their employment claims and they refuse to sign it, I don't want to give them any of my free money. I'm going to take that money, I'm going to put it in a bank, and I'm going to spend it on my favorite lawyer, preferably me, to defend what's going to come. Because if they're not going to sign that agreement, they're going to sue you. And it's a really good early way to figure out whether you've got a friend or a foe in that employee. Common elements, I list them all here. Sometimes you might want to throw in outplacement as well as a nice thing to do. Giving severance is not only good from the standpoint of getting a release and waiver, it's good for culture. It's better when employees leave and they feel okay about you because they are going to talk to their friends that are back at the company, and you want at least to have that kind of feel good as much as possible when you separate. Supervisory training, I'm not going to dwell on this too much, but I do a ton of it. And there's good reason. I'm going to teach you a Latin phrase this morning. You thought you were just going to get coffee in Danish, but you're actually going to get a Latin lesson. And that is respondeat superior. So supervisors, anyone a Latin scholar? You know what respondeat superior is? Lawyers do. Cover your ass? No, that is not what it means. Thank you. But respondeat superior does mean that supervisors stand in the place of the company. Now, if any of you know manufacturing, the prospect of a third shift, whacked out, probably drunk supervisor being the head, the face, and the mouth of your company should really scare you. So supervisors are your best friends. They're the first line of defense. They are your eyes and your ears out on the plant floor, and they are also your worst nightmare in terms of having the rogue supervisor who doesn't follow your rules and regulations. So if you have multiple plants, for instance, you don't want general manager of plant A doing things different than general manager of plant C. That's the definition of discrimination. You're treating similar people differently. Training your supervisors is worth it. It's worth its price 16 to 20 times over. You're going to spend a couple $1,000s training those supervisors. It will prevent everything from workers' comp suits to unemployment costs to discrimination suits to you name it. Have your customers or your clients do it. Do it yourselves. And these are all the different things that I would train supervisors on. Safety and health, We have one of the premier safety companies in the country represented here. Biased plug for our client, SCT, but he would tell you that OSHA and the DOL are out in force like never before. And the days of getting deals done with OSHA and the DOL, frankly, is at an all-time low point. They want their money. And there are very few good deals happening in OSHA land and the DOL world these days. You need to have good representation. You need to have supervisors who are trained on this stuff. And when the OSHA or the DOL comes knocking, they know how to respond. And they don't respond with, oh yeah, those are our good CNC machines with the safety locks, and those are our old CNC machines that don't have interlocks because we jammed a key in there and we don't want to have interlocks on those. The minute a supervisor says that, remember my Latin phrase, respondeat superior. He just put your company in a whole world of hurt because that's a willful. Okay? A willful violation of OSHA. So your supervisors need to be trained on this stuff. Union avoidance, I do a lot of that in the good old days. Unions are at an all-time low too, but if you have the fortune to deal with my friends at the Teamsters, UAW, Steelworkers, knowing how to not only avoid getting them to come in, but dealing with them on a day-to-day basis is also key. ADR, I'm not going to spend a lot of time on. ADR programs are great. Ron alluded to it a little bit before. Essentially, this is just an alternative dispute resolution arbitration type clause. The one nice thing about these clauses is that it keeps your matters private. Your company's name doesn't appear in lights. It's not a public document. It can be handled privately, private resolution. That said, Ron pointed out correctly that the cost benefit of these things has shrunk. And the problem with ADR programs is that if they're not drafted very well, you have a very good chance of not only having one fight, but two fights. The first fight is over whether or not your ADR program is even enforceable, and if you have the pleasure of winning that fight, then you get to go through the ADR. So whether or not an ADR plan is right for you or your clients, I would question. But these are some of the things that need to be thought about when you address an ADR program. Employment audits. I gave a talk maybe 3 weeks ago to a payroll company, and I've got 2 to 3 of these employment law audits as a result. It's a wonderful tool, especially if your clients are a new company or they've got a wet behind the ears HR person who doesn't really know everything about everything or wants to learn. It's an opportunity to bring me or one of my partners in to do a holistic, top to bottom, soup to nuts assessment of your forms, your documents. Are you keeping them properly? Are your handbooks in place? Are they updated? Do you have employment agreements? Are your supervisors trained? There's a whole menu of different things that we can do and come in, and again, for a very, very low cost, proactive front end, dividends will be paid for many years to come. The last bullet point there, EPL insurance. You need to have this conversation with your clients. My partner Lester and I have a bunch of cases going on right now, and in one case, the client, maybe less than a year before, decided, this EPL policy, what's it really good for? I'm going to cancel it. And they did, and Murphy's Law, they got sued, and they don't have any insurance protection, and it's a bad case. It's a tough case with lots of depots, lots of work, and had they had the EPL in place, yeah, they would have paid the first $10,000, but after that, it's the insurance company's problem. And you are in a much different position, settlement-wise, when it's your money as opposed to an insurance company's money. So have that conversation with your clients and think about that with your risk managers going forward. It's not as expensive as it once was. Yes, there are exclusions, but you can negotiate some of those exclusions away. You can work in choice of counsel and a whole kind of other things when you are initially buying the product, because that's when you have the negotiating leverage. Lastly, litigation wrap-up. So what are the causes of litigation? If I had to say the number one cause of litigation, it's lack of communication, and that can include lack of documentation. So when employees don't know why they're being fired, or they're getting cross messages, or they're not sure, I've been doing this a long time. I have yet to hear the employee who says, you know what, in deposition, I really was very bad at my job. Every employee believes they're at least mediocre. Okay? They can always point to somebody else who's worse than they are. Okay? So if you know that going in, and you know that the employee believes in their heart of hearts that they're not bad at their job, when you terminate them, they're instantly going to think there has to be some nefarious reason for it. It's because I'm black, or I'm over 40, or I'm a woman, or I'm whatever. Okay? However, if you've notified them all the way along their tenure with you that their performance stinks, their quality stinks, their attitude stinks, their attendance stinks, and there's write-ups in the file, that communication hopefully will serve you well going down the road, and especially if it gets to litigation with the EEOC, the OCRC, or another attorneys on the other side, and you can throw a stack of paper at them showing that the communication was there. The other thing that causes litigation, emotion, lack of respect. Employers, clients of mine who hire a couple of jackbooted thugs to drag their employees forcibly, throw them in the streets, and then follow with a box of their stuff. Generally speaking, that's not the way to handle employment exits, and that causes a great deal of annoyance, embarrassment, making them do the perp walk past all of their coworkers instead of handling it at the end of the day or early in the morning where they don't have the embarrassment. That causes litigation as well. Why avoid litigation? Well, who here has had the pleasure of being deposed before? Who here has had the pleasure of being in a lawsuit before? Okay. I used the word pleasure. Was it pleasurable? No. It's stressful. It's annoying. You've got to deal with me or one of my partners all the time. It's going to take time away from your work, opportunity cost lost, you name it, stress, money. You want to avoid litigation at all costs. And oftentimes, the cost to prevent it, all the things we're talking about today, are low cost as opposed to once you're in it. How to avoid litigation? Pay attention to all the preventative measures that we've discussed today. While it is not a cure-all or a silver bullet, it will certainly put you in a better position to defend and possibly defeat the lawsuit and or get an early resolution to it. I would tell you this, forget about the golden rule with your employees. Move it up even one step beyond that. Go to platinum rule. Treat employees better than you want to be treated yourself. That will go a long way to helping you out both while they're employees and when they become ex-employees. Don't throw them out on the street. Don't make them do perp walks. Don't hire jackbooted thugs to throw boxes at them and do things like some of my clients have done in the past. Mistakes. The best defense, last. I'm going to give you the 3 magic rules of employment law. Some of you have seen me speak before know that this is absolutely rock solid stuff that is researched and clear. I've written papers on it, years of research, and here they are. Ready? Number 1 rule of employment law, document. Number 2 rule of employment law, document. And number 3 rule, document. However, that last document has an asterisk, and that asterisk goes to the bottom of the page, and that asterisk says, make sure you give me a damn good document. Because a bad document can countermand thousands of good documents. And the case I bring up for that is a tenured professor, a professor who's trying to get tenure at a university, a college that I represented. 3 strikes and you're out. You could go for tenure once. If you didn't get it, you could go for it again. You could go for it again. If you didn't get tenure on the 3rd try, you would never be a tenured professor at this institution. So this professor, Muslim guy, over 40, probably had a club foot or something. He applied for tenure, denied. Stacks of documents, the worst professor ever. Students hated him, peers hated him, performance terrible, didn't publish. Tried again, a couple years later, denied. Same stacks of good documents saying he's the worst professor ever. Nobody likes him. Tries again 3rd year, fails. Stacks of good documents saying all the same thing. Bad performance, bad writer, bad this, bad that. His tenure application goes to the HR department. A 2nd year know-nothing HR woman down there gets the tenure application and writes on the top of it in purple pen, ha ha, 3 strikes you're out, happy face. Not to get technical on you, but that is what we call in the legal business a really bad document. That document got blown up to the size of a wall and got paraded past a jury 10 to 15 times, and that one document countermanded hundreds of really, really good documents. And I learned very early on, as a 1st or 2nd year, I forget what I was, give me damn good documents, because one bad one can sink your ship. With that, I will close and say we will stick around for any questions that you might have. We have certificates for those of you getting credits today. Sarah Cox in the back can take care of that for you, and we'll take questions across the panel, and we'll stick around afterwards. Anybody have a question right now? Joe.
On your employment agreements, can you retroactively apply them to employees after they get off their employment? In other words, I have a group of employees who may not have employment agreements in place. I heard you today, the employment agreements and go back to them and have them signed.
Right.
Can you do that?
Yes. So again, you don't have to bribe them, you don't have to give them $1,000, but you do, if you hand out the agreements, you can do it midstream. They've been employees with you for 10 years, doesn't matter. You can hand them an employment agreement and blame it. There's a great game that I teach my clients to play. It's called Blame It on the Lawyer. Hey guys, you know, our lawyer's telling us that we need these agreements in place, so we're passing them all out. If you have any questions, let us know. Then you got to ask yourself the question, what happens when one employee out of the group refuses to sign it? What are you prepared to do? The answer is, you got to be prepared to fire that employee, because you don't want prima donnas and you don't want one person getting treated different than others. Can you negotiate the agreements with slightly different terms in them? Yes. However, if you get into a lawsuit, one of the things that a crafty plaintiff lawyer is going to do is they're going to ask for all the employment agreements and they're going to look for differences. And they may say that you treated this one differently than this one, and there's nothing wrong with doing that. Some employees are just better than others. Some employees come to jobs with 5 and 6 weeks of vacation time, and you only offer 3. But you're not going to get that employee unless you offer them far more vacation time. You can work that into the agreement. It's a different term, and that's okay. You know, rock stars get treated like rock stars for one really good reason. They're rock stars. So if you got to create different terms for your rock stars, that's okay, but you want to have agreements with all of your employees. Good question, though. Anybody else? Anybody for them? Okay, we appreciate your attention this morning. Thank you for staying with us, and we will stick around for questions afterwards. Thanks, everybody.